Good afternoon. Good afternoon, everybody. Welcome to our Tea Corner, our monthly event to discuss about sustainability together, to have a conversation on sustainability. And today we have Johnny White. Johnny White is of Client Hurt, and he is one of the person more involved in the case of TotalEnergies. There was a judged by the court in Paris for greenwashing activities, for the use of sentences like a major player in the energy transition or the company that consider themselves to be on the path to net zero by 2050. That is quite, very not correct position for a fossil fuel company that has not a transitional way plan for fossil fuel. But I don't want to waste time to Jonathan White. Johnny, the floor is yours for the introduction of the topic.
Wonderful. Thank you very much, Daniele, and it's lovely to be here today. So I'm going to try and share my screen, which may or may not go well. Let me just try and do this, and then I will begin. Um, can you see that all right?
Yes, perfect.
Okay, wonderful. Just let me move this over here. Great. So by way of introduction, as Daniele mentioned, actually an English lawyer. And my background is that I used to be a corporate litigation lawyer for a number of years before I joined Client Earth. And Client Earth is an environmental legal NGO. So we work on issues to do with the law and climate change and environmental protection. And one of the things that we've been doing in recent years has been trying to support and bring about law enforcement action against greenwashing by the most polluting companies. So one of the cases that we supported right from the start since 2022 was a case that was aiming to set a key kind of legal precedent in France on the EU consumer law, and that is the case that was brought by the NGOs we worked closely together with, so Greenpeace in France and other NGOs in France against the major oil and gas company TotalEnergies, which is what I'm going to discuss today. So the first thing I'll just show you here is the extract from the pleadings that the claimants put before the court, which kind of summarizes the whole case. So the claimants argued basically that the consumer advertising of the TotalEnergies group in its retail offering in France was compromised by a key problem. It was saying it was achieving carbon neutrality by 2050 and it was going to play a major role in the energy transition, but this implies a sharp reduction in greenhouse gas emissions and therefore necessarily a reduction in oil and gas production, which are fossil fuels that emit a lot of greenhouse gas emissions. However, in truth, the TotalEnergies group is actually planning the opposite to that. So this case was brought under EU consumer protection law. This is the same law that exists in all EU member states. It comes from an EU law called the Unfair Commercial Practices Directive. What it basically is the law that prohibits misleading claims when they're used to sell products to consumers. And it applies to everything. It's not just green claims. It also applies to practices where traders may mislead consumers about price or about the quality of their product or whatever. And here on the screen, it talks about in the relevant legal guidance from the Commission, what that means for green claims. And it means effectively that green claims have to be truthful, they must not contain false information, they have to be presented in a clear and specific manner. And most importantly, if a trader is making a green claim, they have to have the evidence to back it up. Or else they could find that they'll be challenged by courts or regulators. So the judgment that came out at the end of October was in favor of the claimants. So that means the company lost. And Basically, this was reported quite widely because it is, I think, the first time a court has found that advertising about from an oil major about basically transitioning, being part of the energy transition, was false, and the first time there's been any such judgment from any court in the world. There are similar cases ongoing, but they haven't reached judgment yet. And in the Paris court was the first time that this has kind of happened. So it set a legal precedent for that reason, and I can explain if you'd like a little bit more about what that is in the discussion. So here are some of the press reactions to this. It was reported, as I said, across the European press. What I'm going to do now is just show you some parts of the judgment to try and explain how the judge and how the court looked at this. So the first thing is that this was about actually about a lot of different claims, but the part that is most important is the environmental claim that the company was making about its own business strategy. So essentially what it said on its consumer website, where it was selling home energy to consumers, it said something like, faced with the challenge of climate change, the group is transforming itself with the ambition of becoming a major player in the energy transition. It's accelerating renewable energy and aiming for carbon neutrality or net zero by 2050 together with society. And the judge thought that in this way, the company was clearly expressing that it had a positive approach to the environment. It didn't matter that they used the term ambition rather than commitment. Both things basically mean the same thing, especially to an ordinary person. The second thing I wanted to highlight was that the legal test here does not look at what the company thinks about its claim, and it does not look at what the company really meant with the claim. It's a consumer protection law, and so it looks at the effect of the claim from the consumer's point of view. So the actual legal test asks the judge to assess what the average consumer would understand of the claim. And that's really important because otherwise a company could just say, oh, well, we didn't intend it and we meant something else. And then the consumer could still be misled. So that's what the court's saying here. It's not a question of investigating whether there's some contradiction from the point of view of the company, but instead we have to determine from the consumer's point of view whether the claims are false or misleading and whether they would have affected the purchasing decision making the consumer might make. In other words, was the consumer missold or misled by this? The court did something that we were advocating for quite strongly, so it's good to see, which is that they did not accept the company's argument that the company could define its own strategy. So the company obviously can define its own strategy, but the problem is that in its advertising, it was claiming that that strategy was aiming for net zero by 2050. And what the court said basically was that means something objective. The company can't make up what that is because net zero by 2050 is defined by science. And so the court looked at these kinds of sources to define what net zero by 2050 meant in the eyes of the average consumer for TotalEnergies. So it said the average consumer got the impression from this that the company was really acting to tackle climate change. And to understand what that meant, it looked at the science on climate change. So it looked at the IPCC, the main expert body on climate change at the international level, and how it defines what carbon neutrality is. It looked at a UN expert group report on company net zero commitments and quoted from that report to say the principle of carbon neutrality is incompatible with continued investment in growing fossil fuels. It looked at the UN Environment Programme's reports on the fossil fuel production gap between the Paris goals and plans to produce fossil fuels. It also looked at what the International Energy Agency says about what a scenario that reached net zero by 2050 would be. So it defined what net zero by 2050 or carbon neutrality by 2050 meant, through using all these independent scientific sources. And then finally, it concluded, and this is a bit of a lengthy quote, but I'll just jump to the bit that's in bold. The TotalEnergies group deliberately made an environmental claim likely to mislead consumers by leading them to believe that by buying its products or services, they were participating in the emergence of a low carbon economy following the recommendations of the scientific community in the Paris Agreement. So this was a result that we wanted to see. We wanted to see the court take a robust approach to a company promoting in paid advertising to consumers itself as tackling climate change in line with the Paris goal and actually doing the opposite because of the way that the company is trying to massively expand oil and gas production, which has huge consequences given the size of the emissions that the company produces. So, what you can see today, if you're interested, is if you go to the TotalEnergies website, the French website, the company now has to have a notice at the top of that website highlighting the judgment. And if you click on that, then you will see the what's called the operative part of the judgment, so the kind of order, the court order at the back of the judgment, linked there, and that's one of the things the court ordered. The court also ordered that the company has to cease making the claims. It ordered that the company has to pay the legal costs of the claimants and pay sort of small nominal damages to the claimants as well. The final thing that I'm going to touch on is just to say what might be the part two of this, because it's one judgment in one country. It's on European law, of course, so the same law applies in Italy or anywhere else. But it really is only about one company and actually one advertising campaign. The thing that is happening at the moment, however, is that a lot of the European consumer regulators are proceeding with enforcement on green claims in an organized and coordinated way. So far, we've seen them do this with airlines, following another case that we supported against a Dutch airline. And this is what it looks like. So the regulators, all of them, go to a long list of traders, here 21 airlines, and ask them to commit to not making certain kinds of claim. And effectively, they sort of compel them to reach a settlement and say, we won't make these claims again. So here with the airlines, a month ago, actually, they finally concluded their discussions between the regulators and the airlines. And there's a long list of things that the airlines have committed not to do. So you can find more about that on the Commission's website. I think that it is quite likely, and I think it is necessary actually, that the regulators now take on the energy sector in the same sort of coordinated enforcement. And I expect that we will see that in the next year or two, because it's clear that they follow these kind of court precedents when they have the judgment to back up what they're trying to say. And that gives the regulators a bit of a basis to force a settlement. So I will stop there. Sorry for the speed, and thank you for your attention.
No, thank you, John. It was really interesting. A lot of input and feed for the discussion. And before that, I start with some comment because I already have a list of questions for you, but I really would like to understand if somebody else has already some comment or question for Johnny, because you give us a lot of interesting uh, inputs. I don't see anybody opening the microphone. I want to start with the last point, no? The one of aircraft. A couple of corners ago, we had bad advertising. There was they explained the campaign, no, to ban the advertisement of fossil fuel in the municipalities space,
Mm, mm,
including the aircraft operators.
mm.
So I find very interesting what you mentioned, the last regulatory enforcement document, no, in some way going the same direction. Can you explain a little bit more what is the value of the regulatory enforcement? I'm not the lawyer, so not expert.
Mm.
So how we should interpret it, this kind of document in terms of the level in the legislation?
Yeah, so it is only the court that sets a precedent. So the court is the one that can make a finding about the law. And I should say that TotalEnergies has declined to appeal this judgment, so it is now final because it's possible, of course, they could have appealed it and then it would have, and then maybe it would be changed possibly on appeal, but it's not happening, so it is final. Um, the court is the one that makes the legal finding. The regulators, let's say they are under that, they do not make a legal finding technically because they're not a court, they're not a judge. But they have powers of enforcement, so they can fine companies, they can, depending on the national law, they can maybe order them to do certain things, they can investigate them. And so what we have noticed is that the courts making a judgment is then something the regulators feel empowered to act with. If the court does not make a judgment, you're asking the regulator to go into new territory, and they may be reluctant to do that. So what we've seen is these kinds of big EU-wide enforcement activities, and I should stress it's kind of the whole EU. So it's every nation, every member state's regulator is in this same group. So 27 regulators they do so when there's a judgment that they can rely on. So with the airlines, they're relying on a judgment against KLM from the Dutch court. Now we have the judgment against TotalEnergies in the French court. That's why I expect that they may be looking to now act against the energy sector. But if they did so, it would not just be against TotalEnergies, it would be against a number of or any companies they found in the home energy sector making similar claims. And there's probably more than TotalEnergies, to be honest.
Very interesting. Very interesting. If somebody want to comment, please open your microphone or raise your hand. I see Sabrina. Are you
Yes,
raising your hand? No.
yes.
Okay.
No, I
Rina.
am. I am. I am.
Okay. Go ahead, Rina.
No, hi, Jonathan. Thank you for the intervention. I came across a news article about the Advertising Standards Authority banning certain ads from Lacoste, from Nike, and I think Superdry.
Mm,
Um, and when I saw the ad itself, it was just two words and a paid ad. So it was a long list, a Google ad, and it was just two words, sustainable materials, and they were already, I don't know if if they were penalized, but at least they were banned from using this. Is this
mm,
also, and I remember you said that there has to be, you have to work in unison with
mm,
different regulatory bodies.
mm.
Is this also, can you give a comment on that?
Yeah, of course. So I explained before to Daniele's question how you have like courts that make judgments after, a case has been argued before the court. And then you also have these national regulators that have the power to basically regulate the consumer protection law in the EU. So that unfair commercial practices directive that I mentioned at the start of my presentation. I
Mm,
did not mention you also have what are called advertising self-regulatory bodies.
mm,
So that is every European country also has one of these bodies. So in the UK, it's the Advertising Standards Association. In France, it's the JDP, the Jury of Déontologie Publicité. In the Netherlands, it's the Reclame Committee. Those regulators are not state regulators. They're actually self-regulatory bodies set up by the ad industry. And so
mhm,
they tend to be less, so they have no formal powers, in other words. So when you see those kind of rulings that they put out, like the ones with the clothing companies that you mentioned in the UK, all they're doing is recommending to the advertising industry or the ad agency not to make these claims again. Now, usually that's followed, but it's lesser than the state regulators and lesser than the courts. And
Mhm.
honestly, what tends to happen is like they set out a sort of rule with their ruling, and then the company maybe adjusts slightly and just carries on advertising because they don't have formal powers to punish the company more than just saying, please retract this particular claim, if that
Mhm.
makes sense.
Okay. And but can this be a step, can this can be taken a step further, similar to what happened with Total Energies, that this can be
Yeah.
used, their misuse of these terms can be used legally as well.
Yeah, definitely. So the you were talking about UK, the UK self-regulatory body there, the
Mm,
Advertising Standards Association. The thing that I would say could follow from that would be the UK state regulator, which is called the CMA, or the Competition and Markets Authority. If they started an enforcement action against clothing companies for this kind of thing, that would be the like escalation, if you see what I
mm,
mean. And
yeah.
actually, they have in the past. They did a whole load of like they basically extracted a lot of settlements from I think like more fast fashion businesses and sportswear businesses. I feel like it was like Decathlon and people like that. So
Mhm.
yeah, I would say that yeah, they probably have would those companies would be at risk of that now.
Right. Okay. Thank you.
So now I have the point that the regulator is the AGCM, so l'autorità garante per la concorrenza del mercato is in Italy. So I
Right.
understand the point. It's exactly the body that you issued the fine to do any for the green diesel advertising, in
Yes.
the past. Oh, now I get the point.
Exactly.
Yeah, very
And
good.
and that agency is part of the airline's enforcement because every European regulator is part of that enforcement. So if following that enforcement that I showed you, that an airline makes those claims in Italy, then that regulator should come down, should say stop doing that and order them or fine them if they carry on. But it will remain to be seen how effective the regulators are going to be, I suppose.
Very interesting, very interesting. What about the new directive, the greenwashing directive,
Hmm.
Because you mentioned that the case of Total Energy
Hmm.
was following the regular legislation, no?
Yeah, the old legislation, yeah.
Exactly. Now we have the greenwashing directive. Do you believe that now will be more effective, or it will be easier to complete this kind of processes?
Yeah, so I think the first thing to say is that like the court action should not be the answer because it takes so long and requires so many resources to fight. It needs to provide the example, but we need the regulators and we need the companies to fall into line because it's not possible to take every company to court. Um, the so the legislation is important for that reason. This happened under just the general rule, as I explained. It's just a general prohibition of misleading claims, and it applies to everything. I mean, it applies to environmental claims, but also to price claims or whatever. What has happened since then is that the EU has adopted a specific anti-greenwashing consumer law, and that law is coming into force in September next year. So it is called the Empowering Consumers Directive. And what it does basically is it takes that general rule, the rule that says misleading claims are prohibited, and then it adds specific types of green claim that are prohibited. So underneath that general rule. So, for example, it will be prohibited from September next year to make any claim that a product is carbon offset. So no, you can't say CO2 neutral flight or, net zero bacon or whatever, any product. Um, it is also going to be prohibited to make a future goals claim. So similar to what TotalEnergies was doing, unless you have a detailed and realistic plan to back up getting to that future goal, because otherwise you're just kind of making it up, really. So there are a number of specific banned practices that kind of, let's say they add like detail underneath the general rule in that new law. And what they will do, I mean, I expect that companies will generally start to be a lot more careful with these sorts of claims. And it will make regulators' jobs easier because they can just apply these rules. But I still think that, that there will be probably court actions about this, because I'm sure that the companies will fight over what exactly each of those special, more detailed rules means for them. So I think it'll be a mixture of different things. And I should say overall, I mean, it's really important to stop a company like TotalEnergies selling itself as green. I mean, its emissions are larger than the entire emissions of France. And so if we believe that that company is tackling climate change, that is pretty sure we will not tackle climate change. But at the same time, for transition in society to happen, the really important thing we think is to adopt the same approach that we did when we transitioned people out of smoking, which is to prohibit the advertising entirely, because otherwise you have the advertising going in the opposite direction to where we want transition to go, and it obviously is an obstruction. So yeah, that's what other campaigners work on, as you mentioned.
Yeah, exactly. And the point of the cigarette was exactly the point we discussed together with better advertising for the municipalities. Absolutely. Any other question, comments from the participants? Because you also mentioned one important point in terms of the documentation to support the court position, that investment on climate change are not compatible with the idea of net zero. No, you mentioned that the high-level expert group of the United Nations and the IEA. So I think this is a very important, consideration. Do you believe that this can have some kind of a further implication in other cases?
Yeah, so I mean, this was probably the key single point in the middle of this court case, right? Because these companies like TotalEnergy or the other oil and gas majors, like they mainly work in the upstream of the value chain, and they extract oil and gas and they refine it and transport it and market it, and they have always pursued continual expansion, so new oil fields, new gas fields, in order to support their continued profits, essentially, because each project that they have will over time become less productive, so they want new ones. And the reality is, which is inescapable, is that those products they sell have very high GHG emissions attached to them. So you could even say, if you took the like top 25 emitting entities in the world, they are all fossil fuel producers, and they make up something like 60% of all emissions globally. So you have a huge concentration of the causation of climate change there, basically. So the principle that these companies cannot at the same time be expanding fossil fuel production whilst claiming to be tackling climate change is really important. And it's obviously notable that the companies feel, I'm not in their heads, but they feel it's very important to claim all over the place that they are aiming for net zero by 2050. Why do they claim that? Why do they do that? They do it because it has financial value for them, they believe. And so it's part of continuing the demand and regulatory environment for their product. And that's clearly in opposition to dealing with climate change and averting more impacts. So that's the principle at the heart of it. I think that finding should carry real consequences for the regulation standards in this space because, you can have a standard that says, oh, well, it doesn't matter, but the companies that sign up to that standard could get sanctioned by a court or regulator. So that's not very helpful for the standard or for anyone. So I think that's one consequence of this for sure.
Yes, yes, and also, you mentioned that the role of fossil fuel sector is absolutely in connection with the other TCON that we had from the COP30 in Belém, and the long discussion in connection with the transition away, from fossil fuel. That is really a crucial topic for the COP30 discussion and the lack of positive output. Thank you, Johnny. The 30 minutes already fly very quickly. So it means that the T corner was very, very interesting. And I like to remind that the next T corner will be the 20th of January, so after in the new year. And they will be with the eco and good. So is the economy of the common good with the social and economic value for the companies that want to contribute with the good of the planet. So this is the ambitious of this association. And so, Johnny, thanks very much for your explanation, participation, and for your work in particular.
Thank you, guys, and thank you for your time. Have a great Christmas.
You too. Bye bye. Ciao.
Bye bye.
Ciao, grazie.